This is crazy. This is a total injustice.
Next, we take you to a trial in Lawrenceville, Georgia. 27-year-old Melvin Roberts has been charged with murder, felony murder, aggravated assault, and theft. A year and a half earlier, police say Roberts was hanging out with 23-year-old Jabari Petway, who he knew from high school.
Imagine standing before a judge with your freedom on the line and deciding to argue about your criminal record. That's exactly what happened in Gwinnett County, Georgia, and the outcome was nothing short of a judicial masterclass in setting a defendant straight.
To Atlanta, where he and two accomplices tried to burn the vehicle. Jabari's body was found the next day by a property manager, and investigators were able to track his car to the accomplices, who told police that burning the car was Roberts' idea. When investigators found Roberts' DNA on shell casings and cigarettes at the crime scene, he was arrested and charged. Roberts pled not guilty, deciding to take his chances with a jury. Today, as the state presents its evidence, Roberts is claiming, while the jury is out of the room, that the case is fixed and that there's a conspiracy against him.
This is wrong, man. This is wrong. Y'all using false and fabricated evidence against me, man. This is wrong. This is crazy. This is crazy. This is a total injustice. This is a total injustice.
Roberts then challenges his own cell phone data, which the state contends implicates him in the crime.
Your Honor, you're trying to cover tracks here. You should not allow this to keep going on right now.
We're going to take 5 minutes because I've heard enough.
After a brief recess, the defendant's demeanor does not improve.
You gonna let this go over, man? You gonna proceed like this? This isn't right. This is not right.
By the following day, with the jury once again not present, Roberts continues to interrupt the courtroom, this time turning on his defense team.
Ever since Monday to now, this man, this woman, they're sitting here, they're in cahoots, they're sitting here sabotaging me. And that's just like that pin number. That pin number ain't that man, that ain't that man's card. That ain't that man's card. That pin number was fabricated and put on there. This is not a fair trial whatsoever, and you know this, y'all trying to do whatever that y'all can to sit here and try to convict me. You ought to recuse yourself as my judge. I'll see about y'all, Robert. That's right. That's right.
2 days later, when both sides come to rest, it takes the jury 5 hours to return with a verdict: guilty on all charges.
Here, Judge Law delivers a sharp lesson in judicial authority and the weight of a defendant's record. Thomas interjects to correct what he believes is a factual inaccuracy about his probation status, claiming that his previous battery case was closed. Now, while it might seem minor to him, misrepresenting facts to the court, even unintentionally, can have severe consequences, especially when a judge has access to a defendant's full criminal history. Judge Law quickly asserts her knowledge of his extensive, quote-unquote, 77 arrest cycles, which is a staggering number. This prior record, while not direct evidence for the current charge, heavily influences judicial decisions regarding bond, sentencing, and perceived flight risk or danger to the community. Her statement about originally considering a $5,000 bond, explicitly tied to his perceived disrespect and extensive history, underscores that his interjection directly backfired, costing him leniency that he might have otherwise received. This demonstrates the judge's broad discretion in setting bond conditions, a power rooted in Georgia Code Section 17-6-1, which allows judges to consider various factors, including the defendant's character, history, and probability of appearing in court.
And begins chest compressions as onlookers begin to gather. Another woman comes from across the street to help as Eason continues the chest compressions. After more than a full minute of compressions, the pair desperately continue to apply life-saving measures to Robinson. The efforts of Gary Eason and the woman on the street are successful, as Robinson finally regains consciousness. The first words from Robinson's mouth were, "Thank you." He's then taken to a local hospital by ambulance. During a hospital visit, Robinson thanked Officer Eason one more time. He also told him he received a pacemaker so that Eason would not have to save him again in the future. Next, we take you inside Gwinnett County Superior Court in Lawrenceville, Georgia, for a sentencing. The defendant is 15-year-old Reginald Loftton. He's been convicted of felony murder, armed robbery, and aggravated assault. 9 months earlier, Loftton, along with 21-year-old Jermaine Young, ordered pizza at their apartment complex. When delivery driver Shane Varnador showed up with their food, they robbed and shot him, leaving the 28-year-old to die in the parking lot while they went upstairs to eat. When police investigated, they learned that Lofton's phone was used to place the food order. After searching the apartment, they discovered hidden pizza boxes, as well as the gun used in the crime. While it was unclear to investigators who pulled the trigger, Young and Loftton were both arrested. Loftton, who was 14 at the time, was charged as an adult. Both pled not guilty, and their cases went to trial. After hearing all the evidence in Lofton's case, the jury returned with a verdict.
In the first count of malicious murder, not guilty. We, the jury, found the defendant in the second count, felony murder, guilty.
Even though he was charged and tried as an adult, Lofton's ineligible for the death penalty since he's a minor. Now at sentencing, Loftton appears before Judge Randy Rich to hear his punishment. But before the judge imposes sentence, Lofton's sister, Portia Porter, pleads with the court for mercy.
My brother do deserve a second chance at life. Instead of throwing him under the jail cell, help him. Counseling.
When she's finished, the young defendant briefly addresses Shane's family, including his mother, who's sitting in the gallery.
I just want to say that I'm sorry for your loss, but I did not kill your son. And I wasn't a shooter. That's it, Judge.
The judge's final directives are a masterclass in judicial admonishment. Beyond increasing his bond, she imposes a specific and highly restrictive condition, staying 200 yards away from all MARTA stations and property. This is a common practice under Georgia Code Section 17-6-15, which allows courts to impose conditions on bond to ensure public safety and the defendant's appearance. The explicit instruction on using a proper restroom is directly related to the charge of criminal trespass and public indecency, which in Georgia falls under OCGA Section 16-6-8. This statute prohibits performing any sexual or excretory act in a public place. Judge Law's pointed remarks, though delivered with palpable exasperation, are not just about humiliation. They are a clear warning about the legal consequences of his actions and a strong reinforcement of societal norms. It serves as a blunt reminder that the legal system is not just about abstract laws, but about maintaining public order and safety, and even seemingly minor offenses can lead to significant restrictions when coupled with a history of disregard for the law.
Next, we head to Atlanta, Georgia for an arraignment. Rodney Thomas has been charged with criminal trespass. A day earlier, Thomas, who has previous convictions for aggravated assault, battery, and drug possession, was arrested for urinating in public at a MARTA train station. Today, he appears before Judge Jesse Lall to hear if he'll be offered bond. The state is represented by Ginta Bickerstaff, who's recommending a $3,000 signature bond through pretrial services. Jay Kim, the public defender, agrees with the bond, but prefers that it goes through a jail diversion program called PAD, where community workers help people who've been arrested avoid incarceration. Bickerstaff strongly disagrees with that option.
Your Honor, the state's recommendation to have his bond through pretrial seems more reasonable considering that this defendant just pled guilty to a battery charge, and he's currently on probation for that case as well.
Okay. Bond is set at $3,000. It's going to be a signature bond through the jail.
Judge Law rules to allow Thomas to stick with the PAD program, and the hearing's essentially over. But it looks like Thomas wants to say something.
Here we see the standard procedure for an arraignment. The state prosecutor, GTA Bickerstaff, recommended a $3,000 signature bond through pretrial services. A so-called signature bond, also known as an unsecured bond, means the defendant is released based on their promise to appear in court without having to pay money up front, though they would owe the full amount if they fail to appear. The public defender, J. Kim, agreed with the bond amount, but advocated for the so-called PAD program, a jail diversion initiative designed to help defendants avoid incarceration. Judge Law's initial ruling was to grant the $3,000 signature bond and allow Thomas into the PAD program, which is a fairly lenient outcome for someone with his record. This signals that the judge was initially leaning towards a rehabilitative approach, balancing public safety with the goal of reducing incarceration for low-level offenses. However, this is where the proceedings take an unexpected turn, as Mr. Thomas, despite his attorney's best efforts, decides to interject.
Do you understand? And if you need to answer nature's call, do you know what that means?
Ma'am.
You are to use a proper public restroom or the privacy of your own restroom. You are not to exhibit yourself in any kind of public way in order to relieve yourself. Otherwise, the state's it has its right to charge you with public indecency. Do you understand, sir?
Yes, ma'am, I do.
All right. I can't believe I'm telling a
Here,
grown
Judge
man
Law
how to
delivers a
use
sharp
bathroom.
lesson in judicial authority
This is all
and
shame
the
on
weight
you.
of a defendant's record.
Yes, ma'am.
Thank
Thomas
you.
interjects to correct what he believes is a
Thomas
factual
was released
inaccuracy
on
about his
bond, but
probation
must
status,
continue his
claiming
diversion
that his previous
program
battery case
until
was
his next court
closed.
date. His
Now,
case
while it
is
might
pending.
seem minor to him, misrepresenting facts to the court, even. As for Rodney Thomas's case, the transcript indicates that he was released on bond and was ordered to continue his diversion program until his next court date. Our search for a final verdict or sentencing in this specific Gwinnett County public urination and criminal trespass case involving Judge Jesse Law did not yield publicly available results, suggesting that the case's final disposition may not have been widely reported or could still be ongoing. However, the events of that arraignment stand as a stark reminder of the power of judicial discretion and the critical importance of respecting courtroom procedure and the advice of legal counsel. A defendant's words, especially when defying a judge, can dramatically alter their fate, even in seemingly minor cases.